Welcome to the Probate Nation. My name is Richard Buddy, and I'm the host of the show this evening. More and more these days, we are seeing family members petitioning the court to be appointed to serve as the conservator of an aging parent or family member, and in the process begin the living probate train ride. Efforts to be appointed a conservator begin with a petition to the court, and a series of steps occurs thereafter that typically lead to a court order approving that appointment. But what is often overlooked is the fact that nearly all conservators have to be bonded through an insurance company through what's called a bond with surety. And as we will learn, the insurance companies will not bond every person seeking to be appointed a conservator, which means that if the proposed conservator cannot be bonded with surety, they cannot be appointed by the court. Our guests tonight are two local bonding agents that currently write surety bonds for conservators. They will walk us through the application process to obtain a surety bond and offer some insights on what will and will not be acceptable to bond with surety a proposed conservator. Keith Siegfried is president of Moore Clemens & Company, Loudoun County's oldest insurance agency located in Leesburg, Virginia. Over the years, he has earned the industry designation of Certified Insurance Counselor and the Chartered Property Casualty Underwriter. Presently, he serves on the Educational Committee for the Professional Insurance Agents Associates of Virginia and D.C. Keith is a Virginia Tech graduate who has been an independent insurance and bond agent for more than 30 years. Paula Crouch began working in the surety business in 1980 for Roseberry Bonding Company, a company that is one of the oldest bonding companies in Fairfax County. In 1998, she became the sole owner and agent of Roseberry & Foster Bonding Company, and continues that business today. Please welcome Keith Siegfried, who is here with us in the studio, and Paula Crouch, who is visiting with us by telephone. Thank you both for joining us today.
Good to be here.
Well, Keith, let's take a look. Let's just start with, we need to talk about what exactly is a corporate surety bond. You know, when we talk about this, it's really important to get an understanding about what really that makes up. Can you tell us a little bit about that?
Sure, Richard. Think of a corporate surety bond as an insurance policy. It's a three-party transaction required by the court, taken out by the principal for the benefit of the ward. The principal is required to pay the bond premium each and every year, or as long as the estate remains open. The court controls all the cards here. They control the bond and the bond coverage. The surety guarantees to the court the maximum sum for a loss caused by the principal's action or their inaction. Lastly, one of the most important differences between a bond and an insurance policy is that the principal is personally liable to the surety for any claims that are caused. Therefore, the principal must be able to reimburse the surety for any monies paid to the court.
So it's important to keep that in mind, because that bears a lot in how an application for a surety will be reviewed and acted upon by the insurance company. They want to make sure someone has the ability to pay if it turns out there is a claim.
Yes, sir.
That's very, very important. Paula, let's talk about, how does someone go about applying for this corporate surety bond that, again, we're looking at this in the context of a conservator who wants to be appointed by the court to take control of and be responsible for the money for some elderly person. How do we go about applying for a bond?
Well, basically, we do an interview, whether it's by phone or in person or sometimes email, and based on the answers that they give us, the request for the bond will either be rejected or approved. If the bond is approved, the application will then be sent to them to complete and give it back to us, and so we can further look at the application before we decide.
So the initial thing would be is that they would do some preliminary due diligence. The bonding company would, to see if it makes sense to go forward with an actual full application. Is that right?
Correct. During the initial interview, we ask for the basic details, which the application will ask you for. But in order for us to go on further, we need to make sure that before we send out the application and get too involved, we find out the basic information like employment and their credit scores. We ask if they are U.S. citizens. That is a requirement. And if the bond's really, considerably large, we also ask for an attorney information if there's going to be an attorney that will assist.
So some of the basic details that are important to the insurance company, then of course, is they need to be employed in some fashion, have to have good credit scores, should be a U.S. citizen, and again, I think you mentioned if the bond is particularly large, it's important that we know whether or not an attorney is going to be involved to help oversee that process. Now, Paula, what are some of the factors that will cause a bond application to be denied?
Well, based on what the application says, if they are not currently employed and have not worked in the workplace for a while, we usually, I actually have to go to the underwriter and see if we can do the bond. But recent bankruptcies, very poor credit scores, judgments or liens against them, or lack of citizenship, that's pretty much a no when it comes to approving a bond. And in the event of a large bond, the lack of an attorney involvement is also a detriment to approval.
Okay. Now, Keith, Paula mentioned that credit scores are important, but it's my understanding that there's a different type of credit score that's really relied upon by the bonding companies. Tell us a little bit about that.
Yes, sir, Richard. Most of the bonding companies use Vantage Score, which is a credit score similar to TransUnion or Experian, but it has a slightly different algorithm that's specific for bonding applicants.
Okay, so they've written that scoring based upon their experiences to really give them a better insight into that applicant.
Yes, sir.
I see. Well, there is in fact an application that's fairly typical. This one happens to be for a bond for a conservator, and this is one for Liberty Mutual. And we'll show that on screen to our viewers, and we're going to kind of walk through that just because it will begin to show you the types of questions and the information that's going to eventually be needed as you work your way from initial screening to going to court to eventually showing up at the probate office and actually filling out the full bond application and getting a bond issued. There's things you're just going to have to provide. So, Keith, let's just take a look at that first page for us. So the first section there, as we begin, we get the person's full name, but you see right away they want to know your Social Security number.
Yes, sir.
So we're going to be able to pull some credit scores based upon that information.
Absolutely.
Why is occupation important?
Well, depending on someone's occupation, it's a great indicator that someone demonstrates to the bonding company that the principal has the capacity to handle financial matters, whether it be in their business or in their own personal life.
Okay. Now, I see this question, and Paula mentioned as well, about U.S. citizenship. Now, why is that important?
Well, the bonding company wants to make sure that the principal is going to remain local, be here with us. Obviously, if someone is not a citizen, they're a flight risk. And bonding companies are concerned about flight risk. If someone leaves the area, leaves the country, then it's going to cause the bond to be called upon. So, and not being a citizen, it's very easy for someone to up and leave.
Okay. Now, I see that also they ask for your driver's license number, which we now know is going to be a different number than your Social Security number. Again, why is that important?
Yes, sir. Two reasons. One, it shows proof of residency. Secondly, it also is a tracking tool if we need be.
Okay. Now, again, I think Paula had mentioned that, but there's a whole series of questions that ask about bankruptcy and judgments and liens. So again, does that just go to your creditworthiness?
Absolutely. The bonding companies are concerned about a claim and their ability to collect any monies paid to the court. So keep in mind that the bonding companies are thinking along the lines that, hey, we need reimbursement from the principal for any claims or outstanding matters. Okay.
Okay. So, Paula, let's just take a look. I see there actually is, we look further down that form, there's actually a specific section that talks about conservators and conservator bonds. So tell me a little bit about the importance about the size of the bond. How is that relevant in this investigation process?
Okay, well, we have limits on our authority, so we have that's one of the first questions we ask is, do you know how much the bond will be? If it exceeds my authority, I take the basic information and then it's submitted to the underwriter for the approval. If it's within my authority, I go a little bit deeper and I can decide whether or not they actually qualify.
Okay. And for most agents, what is typically their bonding authority? Is it generally pretty similar, or is it vary by agent?
You know, I think that's a big secret among the agents, what their authority limits
Okay.
are. I have a wide limit for some bonds, none for others.
Okay. Now, another question, Paula, that they talk about here is what is your relationship to the proposed ward? So the person that's going to be a conservator, are they the brother, the sister, the son, the daughter? Is it my grandmother? How is that important?
Well, there's a lot of variances in each conservator bond. It could be a daughter for her mother or a mother for her daughter. We take into consideration where they are, if they are in a facility, how they handle the estate. Sometimes they get to a point where they are guardians, but then they have to change it to a conservatorship if the child is incapacitated.
Okay. Now, I see a question on here about joint control. Is that something that creates a problem in application for a bond?
For conservator bonds or co-conservator bonds, yeah, that's usually decided amongst the family and/or attorneys, and sometimes even the court. But it's not forced upon them. With the insurance company, it doesn't make them do that. It's usually up to the court system. Okay.
Now, the second part of this application, which is page 2, and I just happened to just, we'll show it on screen, is actually the indemnity agreement. And this is something that has to be signed, and this is basically your promise to pay as a conservator, I think, yes, to reimburse the insurance company if, in fact, they have to pay on your bond. Tell us a little bit more about that.
Yes, sir, Richard. This is the clause that warrants the principals becomes personally liable for any claims, and that they will reimburse the surety for any paid losses. I typically get the principal to sign, and if you're married, I also get their spouse to sign. Okay. Because it will be joint as well as individual assets.
Yeah, that's a good point. That's a very good point. Well, let's talk a little bit about the probate office procedures in order to secure the bond. A number of the probate offices we have, over the years we have found, and in some of our recent interviews, they do require that you make sure that the bond has been checked and make sure the person is eligible to be bonded before you actually show up at their office. We actually asked we asked a local elder law attorney if she could share some of her experiences in whether or not she makes sure that her clients are pre-approved for the bond before they actually go off to court and file the petition for conservatorship. And we asked Liz Gray, again a local elder law attorney, to comment about that, and here's what she had to say.
Sure. It's really a horrible thing to get through this whole process, go down to the clerk's office to qualify your conservator for the bond, and they're unbondable. You have to go back and get them removed and have somebody else appointed. It's a long process. I think for most attorneys that do this type of work, we've done it once where we've not had the knowledge to check ahead of time whether the person was bondable or not.
Well, I think that was very helpful information, and again, it reinforces the importance. Paul, as a bonding agent, tell us a little bit about your experiences about getting folks pre-approved. What do you see people doing in your experience as a bonding agent?
Sometimes, most of the time, actually, for me, the call comes directly from the attorney or from someone who has just gotten out of court and needs to has just found out they need a conservator bond. It really makes no difference when they call me, whether they're pre-approved or not. It's more important for them if they need to take care of the ward immediately. Usually someone who's petitioning to become a conservator will know pretty much the value of the ward's estate. So in some cases that's not true. And pre-approval is next to impossible, because if we don't know how much the bond is going to be, we can't exactly approve a bond.
Keith, talk about the Loudoun County process. What happens with those folks? Do they require the bond to be pre-approved before you even make an appointment?
Ideally. There's no question, Richard. If you can get pre-approved, you're ahead of the game. Those folks that don't get pre-approved and happen to go down to the probate office, the probate office is very generous, and what they will meet with the conservator or the principal here that's going to be appointed, explain the process, give them some helpful hints, but they will not qualify the conservator until a bond is pre-approved and duly executed.
Okay. Well, now, the initial bond is generally something, as I think we all know, is established by the court. We get a court order that, based upon all the information submitted, they determine what the bond is. Paula, in the process of reporting to the Commissioner of Accounts, it may very well be that the bond needs to be increased because the assets increase. What happens if that occurs as far as dealing with the bonding company? What does that particular conservator have to do then?
Usually the conservator is contacted by the Commissioner of Accounts telling them whether the bond needs to be increased. From that point, somewhere down the line, they're going to get in touch with me and ask for a bond increase. Depending on the amount, they normally would have to do a new application. If it's something that's been approved by the underwriter and not myself, I would have to turn the application over to the underwriter for her approval, and that's pretty much the process.
So it is possible they may have to submit a new application, and if they have a change in circumstances, it could be that they will not be eligible to get that bond increased.
It's very rare, though, that they don't. Usually the increases aren't that large, and so it's just a technical thing that we have to go through, make sure they sign the Indemnity Agreement for the correct amount of bond that they're bonded now.
Okay. Very good. Now, Keith, we'll talk about bond reductions, okay? As the assets get spent down by the conservator, the amount of the assets under the control of the conservator goes down, which should have they should be an ability to get that bond decreased. Talk a little bit about how that works through your office.
Certainly, Richard. That's a very common question that we get from many conservators, that they were originally bonded for a certain amount, and obviously that amount has been reduced by the payment of various goods and services. Then they will come to us and ask for a reduction in the bond. Unfortunately, we can't authorize a reduction in the bond. The only party that can do that is the court. So either we get a letter from the court or the Commissioner of Accounts authorizing reduction. At that point in time, we will reduce the bond and sign it at the courthouse. I will tell you, for your viewers, that it's a very common question, particularly on the legal side, is they want to get that bond reduced as soon as possible, and that will not happen the first year. It's only on subsequent years.
Okay. Okay, that makes sense. Let's move on to claims on the bond. Keith, what typically triggers a claim on a surety bond?
Well, more times than not, Richard, it's when the principal has not faithfully performed his or her duties, not filed the paperwork or on a timely matter, or not filed in the proper form. That's from my experience, from my side of the desk. However, if the court or the Commissioner of Accounts deems that there's any impropriety with the handle of this estate, they will call the bond due immediately.
Okay. Now, we actually had an opportunity to ask two other elder law attorneys about this issue and what could be done to prevent a claim from being made on the bond. And we asked that question of attorneys Loretta Williams and Valerie Geiger in a prior show, and here's what they had to say.
So the most important thing is to remember that you are dealing with somebody else's money. It is their money. It needs to be kept separate from everybody else's money. You should not be making any loans or any gifts or giving the money to anybody except for paying for goods and services for the person you're protecting. You have to remember that the way somebody, the way Mom handled things in the past may not be what you can still do now. She might have given everybody $10,000 for Christmas, but you can't do that without a court order. So if you follow through that and keep good records of what you're spending money on and have the backup for it, then you should really stay out of trouble.
I think also playing off of Loretta's answer would really be that keeping track, because you're going to be filing your accounting with the commissioner. You want to timely file that account. They're not suggested deadlines, they are hard deadlines. If you need extra time to file your account, don't be afraid to communicate with the commissioner, ask for extra time, and let them know what's going on so you can meet those deadlines.
Well, I think that's very true, that filing properly and making sure that you get things filed timely is very, very helpful. But Paula, what does your office do when there is actually a claim that arises and you receive some sort of notice of a claim? What do you do?
Normally, I would just advise Fairfax County Commissioner of Accounts. I have asked them to just go ahead and let me know as soon as there are any issues at all. If it's just a matter of them late paying their fees, I'll just let that go. But if there's any mention of a claim, that immediately goes to my underwriter and on to the claims department.
Okay. We want to take this a little bit further. We had an opportunity to talk with Kim Murphy about what do you do when you receive a notice from the Commissioner of Accounts with a show cause, where he asks you to come to court, or if you get sued by somebody saying you have breached your fiduciary duty. And here's what Kim Murphy had to say about that.
So when you first get those papers, it's important to seek counsel immediately to just understand what the nature of the proceeding is. If it's a show cause, why is the commissioner show causing you? Is it because you failed to file something? Did you file something incorrectly, improperly, incompletely? A lot of those can be fixed just by talking it through with the commissioner, finding out what was missing. If it's a lawsuit, there's a 21-day response period. And that clock starts when either the sheriff or the process server knocks on your door, hands you the piece of paper. So it's important that you get an attorney involved immediately so that they can understand, well, what's the nature of the claim? And are there defenses? Sometimes it's an heir or a next of kin who's filing the petition, and it's not even through the Commissioner of Accounts office. Sometimes it's just because they didn't see something on an accounting or they're contesting something. Mm-hmm. And other times it's because you spent something you weren't supposed to. In any event, you should look at the papers and contact counsel so that they can review it and go through things with you.
Well, I think that's very good advice, and certainly we want to be proactive and not and get with an attorney as quickly as possible if, in fact, you do receive one of those notices or get served with the lawsuit. Well, we've covered a lot of material about conservators and the need to bond conservators and how do we bond them. I want to ask each of you folks, Keith, you here, and then eventually we'll talk with Paula as well. Your final thoughts, that you can share with our viewers about things that they should do or should not do along the way to make sure that they don't have any claims filed against their bond.
Sure,
Keith?
sure. First off and foremost, Richard, prior to accepting a conservatorship, please get pre-approval from your local bonding agent. Secondly, something that you shouldn't do is, in my experience, is when in doubt, contact your attorney or the Commissioner of Accounts and ask their permission, ask the question. My experience is they're there to help you. It's a lot easier to get permission than it is to ask for forgiveness, because it's not a very forgiving process here if they step out of line. And never, ever commingle your funds with the estate's funds, with the ward's funds.
Okay. Paula, what do you have to say? What are your advice to folks about things to do and not do as they serve as conservator?
I would say that the first thing the conservator has to do is educate themselves on their responsibility. Normally, most of the time, it's the one and only time they're going to be a conservator. And when they go before a probate clerk office to have this bond executed, normally the probate clerk will give you a packet to read that tells you exactly how to file your accountings, and if you have any questions, there are numbers you can call for help. And that's the number one thing. They are given these packets and they don't read it, and then they don't know what they're doing, and then they get in trouble that way.
That's very good advice. Well, Paula and Keith, Paula, thank you for calling in and sharing this time with us. Keith, as well, for coming by and sitting and visiting with us. You guys, you've done a great job of really dissecting this topic down for our viewers. Great public service, and I want to thank you both for taking the time to do so today.
Thank you, Richard. It's great to be here.
It was my pleasure to have both. And Paula, thank you very much as well.
You're welcome, sir.
You know, serving as a conservator is a serious responsibility, which is why the insurance companies carefully screen all applicants and do not offer surety bonds to just anyone. And of course, if a conservator bond is forfeited, there is the fact that the conservator is personally liable to the insurance company. The message I draw from the discussion today is that every conservator should get advice from an experienced elder law attorney both at the outset when seeking to be appointed by the court and again thereafter when they leave the probate office having been duly qualified and empowered to act as a conservator. It is so easy to make an unintentional mistake and yet often easier to avoid that mistake with an experienced attorney guiding you on your living probate train ride. But if you should face enforcement action against you by the Commissioner of Accounts or some third party, please get litigation counsel involved immediately to help, as these enforcement actions can often be resolved. This brings us to the conclusion of our show today on bonding the conservator. Hope you found it informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of the Probate Nation and myself, thank you for visiting with us.